Definition of tort. A tort in common law jurisdiction is a civil wrong other than breach of contract that causes a claimant to suffer loss or harm, resulting in legal liability for a person who commits a tortious act. Tort law involves claims in an action seeking to obtain a private civil remedy, typically money damage. Tort claims may be compared to criminal law, which deal with criminal wrongs that are punishable by the state. Tort law may also be contrasted with contract law, which also provides civil remedies after breach of duty that arise from a contract. But whereas the contractual obligation is one agreed to by the parties, obligations in both tort and criminal law are more fundamental and are imposed regardless of whether the parties have a contract. Definition of negligence. Negligence is a failure to exercise appropriate and or ethical rule care expected to be exercised among specific circumstances. The core concept of negligence is that people should exercise reasonable care in their actions by taking account of the potential harm that they might foreseeably cause to other people or property. The law on negligence may be exercised in general terms according to five-part model, which include the assessment of duty, branch, actual cost, proximate cost, and damage. The modern tort of negligence. A duty is imposed on a person by law to act with care toward others. If this duty exists and there is a failure to act carefully and others suffer loss, then the tort of negligence is committed. There are two types of negligence. First, civil, minor personal injury and property damage. Second, criminal, result in death where there was no intention of injury.
Injury or harm as a consequence of the breach. Duty of care. A person owes a duty of care to another when the reasonable person will foresee that the others will be exposed to the risk of injury. For example, a driver of a vehicle owes a duty to anyone within the area of risk when moving. Other road users, pedestrians, the owner of adjacent land and building. Situation in which of care applies. First is negligence misstatement in relation to people being advised. Second is school authorities to student. Third is occupier of premises, to person entering the premise. Fourth is bailee of goods, to bailer. And fifth is dog owner, to people who may be beaten. 6. Suppliers of goods or services, to person being supplied. Second, breach of duty, unreasonable running a risk and harming to the others or their property. This one will be presented by my next class. Thank you.
Hi, Assalamualaikum. My name is Nurhanja Azhari. So I want to present about my part. Okay, my part is a strict liability. Okay. In some situation, the court will present a breach of duty of care based on the existence of certain factors. If someone injured, the defense is presumed to have breach of the duty of care. Next, and a factual causation. Factual causation is a defense is held liable if the particular act of or composition where the cause of the loss is damage substance. Basic test of causation is to ask, but for or without my breach of duty will you be harmed? If not, I'm liable. And the damage will provide injured a compensation for successful negligence suit, and damage may be psychological, economic, both reputation and emotional distress. The sum of money awarded by the court of harm is suffered by the claim. Thank you.
Hi, my name is Abdurrahman and I'm going to present here types of damage. Types of damages are special damage, general damage, and punitive damage and aggravative damage. Special damage are qualifiable dollar losses that are suffered from the data of defendant negligent act tort up to the specified time proven trial. Special damage example of special damage include loss to wages and medical bills and damage to the property, such as one scar. Okay, and then general damage there are damage that are not quantified in monetary term. Example, there is no invoice or recipient there would be proof special damage. A general damage example is an amount of pain for the pain suffering from experiencing from a car collision. The other type of damage is punitive damage, which is punitive damage punish a defendant then compensate plaintiff in negligent cases. It most judicious punitive damage are recoverable in negligence action, but only the plaintiff show that defendant's conduct was more than ordinary negligence. Example, wanton and willful or reckless. The other type of damage is aggravated damage, which is aggravated damage. It contrasts the exemplary damage. Compensation are given to the plaintiff when the harm is aggravated by the defendant's conduct. For example, the manner of this wrongful act increased injury by suffering plaintiff humiliation, insult. Hypothetical personal injury cases. Do not speed through in section against red and hits a vehicle driven by the Pat who had green light and right way to. Pat was injured. The personal injury dispute is based on case of negligence. What is the duty of the care? How was the breach of the duty caused? Describe the factual caution. What was the damage? Essential expressions: act or omission, which means damage or an injury. Foreseeable harm or injury, damages or equals compensation. A reasonable prudent person to commit a negligence. Duty of care, to avoid a damage. Breach of duty, to breach the duty. Factual causation, which means to cause harm. And proximate cause. That's all for my part.
Assalamualaikum, my name is Fatin Aisha. So my part is the case of Tort of Negligence. It is between Donoghue versus Stevenson. Donoghue versus Stevenson is one of the famous cases in British legal history. It laid the foundation of the modern law of negligence, established general principle of the duty of care, also known as the pasty snail or snail in the bottle case. The case involved Mrs. May Donoghue drinking a bottle of ginger beer in a cafe in Paisley, Renfrewshire. Unknown to her or anybody else, a decomposed nail was in the bottle. She fell ill and subsequently sued the ginger beer manufacturer, Mr. Stevenson. The House of Lords held that the manufacturer owed a duty of care to her, which was breached because it was reasonably foreseeable that failure to ensure the product safety would lead to harm to the consumers. There was also a sufficiently proximate relationship between the consumer and the product manufacturer. Prior to Donahue vs. Stevenson, liability for personal injury in tort usually depend upon showing physical damage inflicted directly, which is trespass to the person, or indirectly trespass on the case. Being made ill by consuming a noxious substance did not qualify as either, so the orthodox view was that Mrs. May Donahue had no sustainable claim in law. However, the decision fundamentally created a new type of liability in law which did not depend upon any previously recognized category of tortious claims. This was an evolutionary step in the common law for tort and delight, moving from strict liability based upon direct physical contact to a fault-based system which only required injury. In the House of Lords on 26 May 1932, Lord Atkin arose to deliver a judgment that would have a lasting impact on society. His decision established that a manufacturer of a product owed a consumer a duty of care. So, the next one is explanation of the neighbor principle. Lord Atkin's speech became renowned not only for its role in established negligence law, but for its articulation of the neighbor principle. When looking to establish an underlying foundation determine duties owed between parties, Lord Atkin turned to the biblical parable of the Good Samaritan as a basis for what would become known as the neighbor principle. Who? Then in my law is my neighbor. The answer seems to be that the person who are so closely and directly affected by my act, but I ought reasonably that have them in contemplation as being so affected that I'm directing my mind to the acts or omission which are called in question. You must take reasonable care to avoid acts or omission when you can reasonably foresee would be likely to injure your neighbor.
My name is Alia Haida. I would like to talk about the neighbor principle. Neighbor principle is persons who are so closely and directly affected by my act that I thought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions that are called in question. For example, consumption of products. Consumption of products is a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they love him with no reasonable possibility of intermediate examination, and with knowledge that the absence of reasonable care in the preparation or putting up of products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. Next, medical negligence. Legally, medical professionals are accountable for their duty of care to prevent foreseeable harm which can either be the result of an actual act or an omission that is to the detriment of the patient's interest. Medical negligence is viewed as direct result of failing this duty, which is prosecutable for the injury it causes. In conclusion, negligence as a tort is a breach of a legal duty to take care which results in damage undesired by the defendant to the plaintiff. The elements of liability in tort of negligence can be outlined as follows. The defendant must owe the claimant a duty of care, must be in breach of that duty, and must cause loss to the claimant. The loss cause must not be too remote and must not be able to raise a defense to the claimant's actions. That's all from our group. Thank you.